All right, everyone, just give us a moment. We're waiting for your attorneys to come in. So just give us a moment. can you call the people who are on Zoom and see where they are, because we're going to start up at 2:30. And can you call the attorneys on this case and have them to come over to court? I know I told them we were starting up at 2:30, but I need to know if they have any objections to the jury charge.
What happened?
All right, everyone needs to share their video. Mr. Hitchens, who is your client?
Judge, it was an inmate, Mr. Rada. He just needs you to follow up with one of the prosecutors from Criminal Trial Division.
Mr. Hitchens?
That was quick.
Yes. Who did you need to speak to, Mr. Hitchens?
It's a regular prosecutors on a burglary of a habitation. Ideally, the same prosecutor that talked to Christine McDonald, who represents Julian Vara on an earlier case.
There's one in there. There's one in there.
I can talk to him, Judge.
I'm going to send you to breakout room number 2, and a prosecutor will meet you there.
Okay.
Judge, can you send me to number 2 or make me a co-host, please?
Yes, I'm doing that now.
Thank you.
You're welcome.
right there. As soon as I get out of court, I'm still in court. Yeah, they got me in here.
Oh, please have a seat. All right, Mr. Hitchens.
Okay. Yeah, I'm here. I just met with Assistant DA Joe Ray Garcia.
On which case?
My cases are oh goodness, I've got the indictments here. 2022 CR 15.
What is the defendant's name?
It's Julian Vara.
All right, and is that case on the docket today?
Yes, it was, Your Honor.
All right, to the courts, could you bring me that file, please?
Well, it's actually multiple files, 2022 CR 1541 and 1542.
All right, they should have all of the files. To the clerks, if you can bring those files to the court room, please.
Yeah, Judge.
She had it all.
was today, that the judge extended your, stay for another, 2 months. Yes.
All right, what is happening with your client? Mr. Kitchens?
What is happening, Judge? I found out this morning that he has a third case and a different lawyer representing him. That's 2022 CR 1471. That's a burglary of a building. He's represented by Kristen McDonald of the Public Defenders Unit. And then from my meeting with Assistant DA Joe Ray Garcia, I learned that there are 2 sealed indictments going back to November of 2021 that also my client is a defendant in. And Mr. Garcia wanted to look at those cases in terms of coming up with kind of a global offer.
All right, is your client in custody or on bond?
He's been in custody since November 17, 2021.
All right, did you have a chance to speak with your client today?
I did, Your Honor.
All right, Ms. Ferguson, on Mr. Vara. Can I have a 30-day reset, please, in the chat box? And state on Mr. Vara, what are the alleged new cases?
They're both burglary of habitation, Your Honor.
And Mr. Hitchens, I'm assuming you'll be placed as the attorney on those new cases.
I'm assuming I will be,
right,
unless
come
the
back.
DA's office decides not pursue them.
All right, we're going to come back on April 26th.
Okay.
All right, Mr. Hitchens, unless you have something else with us, you're excused.
Okay, and on that date, probably the Ms. McDonald also needs to be given notice on the felony case she represents him on also.
Yes, she will be informed. But as you know, that's a state jail felony and the rest are not.
Okay, well, thank you, Your Honor. May I be excused?
Yes. All right, where is Mr. Acevedo on his sentencing today?
He's back here with us, Judge. He'll be up there in just a few minutes.
All right, well, he needs to do it now, otherwise he's gonna have to wait until after this trial. And to the clerks, if you can bring me the file on Mr. Acevedo's client, please. Where's the file? Acevedo's client. Oh. All right, and before we go on the record on this case, the state, the defense is saying that they want to change their election.
We have no objection to that.
Judge, I just resent you the PSI and tap on Mr. Silva.
All right, thank you.
Somebody is it. Joseph Acevedo's in the back asking for it.
All right, is his client here? He needs to come in the front and ask for whatever he wants to ask for,
Oh,
because continuances are not given back there.
okay.
Is there Mr. Silva here? All right, who's the prosecutor on Silva?
Church,
Yes.
I haven't seen the PSI. And there you go, tap it off.
All right, Ms. Reyes, can you print out, send the TAP evaluation to Mr. Acevedo or Mr. Silva, please?
Joe Ray sent him the tap earlier this morning.
So you
You
should
sent it to
have
me?
it.
Okay.
All right. Are the jurors here? Let's bring the jurors out. Yes,
Are we gonna break the and go over the charge?
well, they are calling a witness. That's what my understanding is. And then, so the charge has to be changed slightly to add that. And I'm waiting for them to send that down. All right, the state said they would have no objections to you changing your election.
Okay, and I just have one more thing to tell you. And we do have a quick matter for the court outside the presence of the jury before they come in. I think it'll be
Yes.
quick, Judge. At this time, the defense would move for a directed verdict.
Well, just one moment, because
Oh, I'm sorry.
Brea, are you ready?
I'm ready.
We're calling 2019 CR 11721, State of Texas versus Roland Huerta. Can I have parties announced for the record for the state,
Marcus Sanders.
for the defense?
Rick Ramos, Your Honor.
All right, defense, you have a motion?
Yes, Your Honor. At this time, the defense would move for a directed verdict. At this time, the defense does not believe the state has put on sufficient evidence, yet alone any evidence in regards to the chainsaw being used in any manner that would justify the charge of aggravated assault with a deadly weapon. We heard the victims testify in regard, or the victim and his brother testify in regards to Mr. Huerta turning it on. But we never heard of anything actually being thrusted forward or being used in a manner that could potentially cause serious bodily injury or death. It never got to that point, aside from the struggle which the victim said himself that he initiated, and he came forward before anything could happen. So with that being said, we don't feel there's enough evidence to go forward, and we'd ask for a directed verdict from the court, Your Honor.
State?
Judge, our response is that there was sufficient evidence to go to the jury regarding the use of force on the victim. And the brother testified that the chainsaw was on, and that he pointed it at the victim, Roberto. At one point, they were fighting over the chainsaw, and the chainsaw broke the glass door that was behind. Initially, the victim said they feared for his life, and the deputy testified that it's the chainsaw is capable of serious bodily injury or death.
All right, all right, that motion will be denied. Is there anything else before the jury is brought back in? All right.
All right, to the jury.
All right, everyone, please be seated. Defense?
Yes, Your Honor. At this time, the defense would call Mr. Roland Huerta.
All right, Mr. Huerta? All right, thank you. All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
So help me God.
All right, you can lower your hand. You can state your name for the record, please.
Roland Huerta.
All right, defense.
Thank you, Your Honor. Mr. Huerta, can you tell the jury how old you are, please?
I'm very-
Married, kids, or anything?
I'm married and I have 4 children.
How old are they?
Objection, relevance.
That'll be overruled.
How old are your kids?
My oldest is 17. I have a 12-year-old, a 13-year-old daughter, a 12-year-old son, and a 6-year-old daughter.
What do you do for a living, Mr. Huerta?
I own a tree service company, also a utility company, and we also do dog breeding as a family.
I want to talk to you specifically about why we're here. You understand why you're here today?
Yes, sir.
Okay, do you recall what happened on or about March 5th, 2018?
Yes, sir.
Okay, I want you to explain to the jury, what was your relationship with Rigo and Manuel who testified today?
Those manual was, they both are my two tree trimmers that I use, and they do both groundwork and tree work. I am their boss. And
You were the boss back then?
yes, sir.
Okay, do they still work for you? I'd imagine not.
No, sir.
Okay. Up until March 5th of 2018, did you believe that Rigo was still working for you?
On March 5th. On March 5th?
On March 5th, the day that this incident happened?
On March 5th, no, he was not.
Okay, when did you find out that he was no longer working?
I found out on March 5th that he was no longer working for me.
How'd you find out?
He called me that day in the morning around 11 and said, hey, can I use one of your tools, your power pruner?
Was that a strange call?
Yes, very strange.
Why?
Because he was working for me the day before. So when he called me and asked me for a power pruner, it was in suspense.
Okay, when you say he was working for you the day before, you mean March 4th?
Correct.
Where were you guys working?
We were working at the job down the street prior from the incident that had happened.
Did you see the map that I had showed the gentleman when they were testifying?
Yes, sir.
Okay, I'm gonna show you that map, and I'd like you to point it out to the jury. If it's there, and for the record, I'm showing him defendant's exhibit 1. Are you able to see the houses on this photograph?
Yes, sir.
Okay, and I believe that's a touch screen right in front of you. Can you show the jury where you were working at the day before?
We were working in this section, right, this property.
Okay, so would that be the house located on Forest Trail with the address of 8906?
Yes, sir.
Okay. Had you ever spoken with the individuals at the other house where this incident happened?
Yes, sir.
Okay. Did you talk to the owner himself?
Yes, sir.
Okay. What was the conversation about?
It was about giving them a quote for his trees, where in the backyard where they were gonna have a gathering for his mother that had passed, and he wanted the trees to look very nice for her. So it was just working in the back for that property.
Did you give him a quote?
Yes, sir.
Okay. Was Rigo working for you at the time that you gave him that quote?
Yes, sir.
So when Monday rolls around and you get the phone call asking to borrow tools, what were you thinking?
I had asked him, why would you need my tool? And he was like, well, the job that you gave did yesterday.
I'll fix them, Your Honor.
All right, that objection will be sustained.
I don't want you to get into what Rigo told you. I just want to know kind of what were you thinking, what was going through your head when one of your employees is calling you asking you for tools. What were you thinking?
Why would you be calling to use one of my tools?
Were you expecting him at work that day?
Yes,
What time was he supposed to show up for work?
9:00 a.m.
And did he show up at all?
No call. No, sir. No, he did not show up.
Okay, and did he tell you that he was going to show up or not?
The day before, automatically assuming he would show up to work.
So did he tell you he was not going to show up?
No, he did not tell me he wasn't going to show up.
Okay, so was this the first time that you heard from him that day when he asked for tools?
When he asked for tools, it was already 11:00.
Okay. What did you do after he asked you for tools?
I went to the estimate that I went and did the day prior
So how did you get there?
by foot.
You walked to the house?
Yes,
How did you know he was there?
he told, he told me that,
Objection, you're safe.
Sustained.
Just don't get into what he told you, but, I mean, did he tell you he was there at the house?
yes,
Objective, you're safe. Objection.
Sustained.
Mr. Huerta, so you go to the home, what were you going over there to do?
to notify him it was nice working with you. From now on, no longer call me for any work. And good luck.
Okay, what happened after that?
After that, I parted ways and went back to my original job.
Okay, later on in the day, you did go back to that house, correct?
Yes, sir.
Okay, can you explain to me why you went back?
I went back because I needed to paint wounds for oak trees. If you don't paint wounds on oak trees, I can get sued if those trees die 10 times the amount of what that tree is worth. So I'm obligated to, as a company, I have to paint those wounds.
Okay, and just explain to me, because you have to forgive me, I don't know very much about trees and whatnot, but what do you mean when you gotta paint the wounds? What does that mean?
We call painting another form is called seeding. You have to seal oak trees, any types of oaks, red oaks, live oaks, Mexican oaks. You have to seed them to make sure they don't, so a certain bug doesn't stop the moisture of that tree. So we have to seed them to prevent that from happening. And the disease is called oak wilt.
So do you mean sealing like once you cut something off of it,
Yes,
like the part that's exposed?
yes.
What kind of tool do you use to do that with?
It's an extension paint pole that extends about 3 stories high.
Okay, if I show you a picture of one, would you recognize one?
Yes, sir.
I'm gonna show you what's already been marked as State's Exhibit 14. We heard some testimony in regards to you going over there thinking they had stolen something from you. We're gonna get into that. But I just wanna know if what we're looking at here, at State's Exhibit 14, is that a painter's pole?
Yes, sir.
Was that what you would have used to seal those wounds that you're talking about?
Yes, sir.
Okay. What had happened with your painter's pole? Why didn't you use yours?
Mine was no longer on the job site from the day before that we had used.
Okay, where was it? If you know.
We haven't located yet.
Okay, so who was the last person to use the painter's pole?
Rico,
Okay, so did you assume that he had taken it?
yes.
Okay, so I guess tell me, what did you do? Did you look for it at your job site? How did that go down?
I looked in the back, the sides, the front. I looked in the back of my truck. Nowhere to be found.
Okay, so what did you do after you couldn't find it anywhere on your job site?
Once it wasn't on my job site, I walked to the other property to see if my paint pole was there.
Okay, what did you do when you got to the property?
When I got to the property, I knocked on the front door. The front door was open. There's a screen door that was closed, but the main door was open, so I can see the kitchen from the door. Nobody answered, so I walked to the back. I see the paint pole, I grab it, and I just start walking back out away from the property.
What happens after you grab the paint?
Once I have my back turned from them, Manuel comes and just grabs it, snaps it right out of my hand.
Okay,
I'm not holding it real tight.
let me backtrack real quick. As you're making your way back there, did you see the brothers?
Yes,
Okay, I want you to show the jury on here, you can write on that screen. Can you just make a little mark at the first location? Let's kind of try to draw a timeline here. You recognize the house that you went to there?
yes.
Okay, where did you go knock on the door?
There's a front door, this section right here.
Okay, nobody answers, where do you walk through?
So I'm gonna walk you through it. I walk this side, There's another pathway here that goes into the driveway, it meets up here, there's a little V. I'm walking towards this section here. So once I pass this section here, I automatically see the paint pole right where Regal is at.
Can you put a small little X, or let's do it this way. Well, yeah, an X and a circle where you see Rigo. Circle that X for me. Where do you see manual? Go ahead and put like an M and circle that so we know where manual is in this scenario.
Manual's right in the corner right here of this home right here.
And so the painter's pole you mentioned is right by where Rigo's at.
Correct.
Is Rigo up on a tree? Is he on the floor? Where's he at?
Regal's up on the tree.
Okay. So you grab the painter's pole. Where do you walk to?
I walk towards the painter pole. Or towards Regal. Right in this section here.
Okay. You grab the painter's pole. Where do you walk next?
Can you carry this?
Please. Where do you walk to next?
Okay, this is where I am right here, where I grab the painter's pole. I automatically start walking back this way.
Okay. What happens when you get there?
That's when I already start walking here where I had stopped. That's where manual started coming from this way and grab up the paint pole here. Off of from back of me.
What happens after Manuel grabs the paint pole?
Manuel says that this is his paint pole. And I just say, show me the receipt. He said he just purchased it. So I just say, show me the receipt. And he just keeps saying, this is my paint pole. We go back and forth saying repetitive 4 times, 5 times. Show me the receipt. This is my paint pole. Show me the receipt.
What is Rigo doing during this?
Rigo is getting down from the tree and saying, this is all the tree service is not yours.
What does he do once he gets down?
Once he gets down, he goes and grabs the power pruner.
What's a power pruner?
A power pruner is a chainsaw that extends about 14 feet.
If I showed you that power pruner, would you recognize it?
Yes, sir.
Don't have great picture, but I'm going to show you States Exhibit 9. Hold it a little closer to make it easier to see. Do you recognize where the power pruner is in this photo?
Yes, sir.
Where exactly is it?
The power pruner is this extension back here.
So to be safe to say it's basically a saw and a long stick.
Definitely.
Okay. What does he do with that power pruner?
Once he grabs it and turns it on and says he's gonna kill me. And he says that I'm gonna F you, kill you, but I'm gonna kill you.
Does he seem very upset?
Very angry.
Okay. What does he do after he says that?
He's still trying to turn it on. Revs it about 4 or 5 times, doesn't turn on. He goes back to where his chainsaw is, by the tree.
Okay. What does he do with the chainsaw?
First, he puts the power pruner down and he grabs his chainsaw.
And then
He starts revving it. He says it again. I'm gonna F kill you. And I'm gonna F kill you.
okay. Did you believe him?
I didn't believe him. Honestly, did.
What does he do next?
He comes towards me. I'm not thinking he's gonna do it until it finally gets about 1 foot to 2 feet away from my face.
What happens next?
That's when I have to defend myself.
In what way?
I I have to get a hold of his hand and the chainsaw.
Okay, what happens after you grab his hand and the chainsaw?
After I grab the hand and the chainsaw, I kind of grab it where we're both like this, facing upward.
Okay.
And we're kind of fighting with it to what direction it's going. So I kind of have it going down to my right-hand side.
Okay, what happens next?
When I have it going down to my right-hand side, that's where he's already against the trailer. And that chainsaw is touching a tire. Contained. Trying to keep him contained at the same time the chainsaw.
Okay, give me a second. Well, may I approach the witness, Your Honor?
Yes.
Yeah. Your Honor, at this time, we would move to admit defense exhibit 7A is what I'm gonna call it, because it is only a blow up and a little bit clearer photo of state's exhibit 7.
No objection, Judge.
All right, I'm sorry, states, you're saying it's defense?
I have it
7A?
labeled as defense exhibit 7A. I can put a state's finger if the court would like.
No, that's fine. All right, defense exhibit 7A is admitted.
Permission to publish the jury, Your Honor?
Granted.
Now, I'm showing you, it's just a close-up, or I guess a clearer photograph of the one we've got here from the state. And you mentioned that you've got them backed up. Which trailer are you talking about? Because there's two in this photograph.
This trailer.
Okay, the tire that you're talking about, where are you holding the, I guess, where are you guys struggling with the chainsaw?
We're struggling with the chainsaw right here.
Can you show us which tire you're talking about?
The tire that the chainsaw was touching is right here.
Okay. And are those the marks that we see there on the tire where you're talking that the chainsaw was touching?
Yes, sir.
Okay. What happens after you guys are struggling, the chainsaw's on the tire, what happens next?
Next, that's when that's when Manuel hits me in the back with the paint pole.
Okay, what happens after Emmanuel hits you with a paint pole?
When Manuel hits me in the back in the paint pole, that's when I grab Rigo with my right hand and a chokehold to switch his position and my position so I can have control of Rigo and the chainsaw. At the same time, have Manuel in sight in front of me, and he's no longer in back of me.
What happens next?
That's when Manuel is still saying, "This is my paint pole," and I'm still saying, "Show me your receipt."
And then?
So finally, Rigo turns off the chainsaw.
What happens after Rigo turns off the chainsaw?
Again, Manuel says, "This is my paint pole." I let go of Rigo, take 2-3 steps back. I say, "Show me your receipt." Manuel goes to the car to get the receipt.
Which car does he go to?
He goes to his wife's car.
And I believe he testified, but would you mark for the jury as well where you saw, did you recognize where his wife was at the time?
Yes.
Okay, would you show the jury where? He's right set up, I'm sure that would help. Where was his wife at the time?
His wife's car is in this section right here.
Okay, she was inside the car?
Yes, sir.
Okay, what happens after he goes to his wife?
He comes back with the receipt.
And she shows you?
Yes, sir.
And then what happens?
I see a $45 on there. So that's when I started walking away, going towards my job site. That's when I see the wife in the car and I hand the wife back the receipt. And I go back to my job.
Did you realize you had made a mistake about them stealing the paintball?
Yes,
At any time, were you the aggressor in that situation?
never,
Were you the one to grab the chainsaw and try to go after Rigo?
never,
Did you ever try to go after Manny?
no.
Pass the witness.
State,
Hey, Mr. Huerta, how long have you been doing construction or landscaping and such?
Tree service for 7 years.
Okay, how long had Rigoberto and Manuel worked for you?
They worked for me for about 3.5 years.
Okay, and then this address 25602 Grotto Trail, had you done work at that address before?
What's the address?
The address where the offense happened?
No.
Okay, and so, but you had put in a bid,
Yes, sir, the day before.
and then you find out that Rigobert or Manuel had underbid you, right?
Yes,
And so you're telling this jury that you found out that he underbid you on a bid that you had made the day before, and then you go over to tell them thank you? Is that what you're telling the jury?
thank you.
Yes, that it was nice working with them, and you thank them for working for you.
Yes.
Okay, so you weren't angry that they underbid
No,
and that they went out on their own and was stealing business from you?
no,
Okay, and so then you leave and you're telling the jury that you came back later on and that you saw a pole that you thought was yours, correct?
correct.
And you went looking, why did you go looking for the pole at that address?
Because Rigo was the last person with the pole the day before that sealed the wounds. He called, he told me geez. I know they were there at the other job.
Okay, and so you thought that they had stolen from you.
Yes,
And so you're angry, I guess, were you angry that they had stolen from you?
no,
Okay, so you're not angry that they underbid you and you're not angry that they had stolen property from you.
no,
Okay, and so then you're telling the jury that then you go there and you take the tool and you just start walking away without saying anything.
correct.
And so what happens after Manuel takes the tool back from you as you're trying to walk away?
Manuel just keeps saying that's his paintball.
Did you try to take a paintball from him?
No, I just said, show me your receipt.
Okay, and so you were gonna give him back the paintball.
I left the paintball there after he showed me the receipt.
And so while you and Manuel are supposedly talking about the paintball, that's when Rigoberto comes down and allegedly threatens to attack you.
Yes,
Okay, and you're telling the jury that at first he tried to attack you with one saw and then he picks up another saw.
yes,
And while he's threatening to attack you with saws, you're still standing there.
yes,
And then you said that he got close to you about a foot away and you still were just standing there.
after he got a foot towards me, once the chainsaw is a foot or 2 feet away from my face, I have to defend myself.
Okay, and let's talk about you defending yourself. At what point did the glass get broken?
The glass got broken as soon as it's close to my face. We're fighting for it. While we're fighting for it, that's when he steps his back towards the trailer.
So you're saying it's not the saw that cut the glass, it was the back?
Yes,
Okay, and so at some point, you're telling this jury that Manuel hit you with some sort of pole.
yes,
And while he's hitting you with a pole, and while Rigoberto is trying to attack you with a chainsaw, you're able to grab both. You're able to keep him from hitting you with a chainsaw and hold on to Rigoberto.
yes,
Okay, and so you have one hand on each, and he has 2 hands on the chainsaw trying to attack you.
yes,
And then all of a sudden, he just turns off the chainsaw.
yes,
Did you say anything to make him turn off the chainsaw?
no.
Okay, so he just was done attacking.
I would say probably had him in a pretty good chokehold. If you have him in a pretty good chokehold, he probably was about to faint, so he turned it off.
So how were y'all standing? If you had him in a chokehold, with which hand?
Then I had him in a chokehold,
Yes, sir.
am I right?
Okay, and then with your left hand, you had the chainsaw?
I was holding his hand and the chainsaw with my left hand, correct?
Okay, and so how far out was the chainsaw?
Arm distance.
Okay, and so what was he, like, was he hunched over?
Hunched over, yes, me and him, yes.
Okay, and so,
Me and Rigo,
yes,
yes, sir.
and so your left arm is stretched out and your right arm has him in a headlock. And you're telling me that you're that much stronger than him that he wasn't able to pull the chainsaw from your one hand while your right hand is choking.
Correct.
Okay, and then Manuel is just standing by watching you choke out his brother.
While the chainsaw is positioned towards Manuel, Manuel is trying to still hit me with that paint pole. So we're maneuvering. I'm maneuvering Rigo, maneuvering the chainsaw, trying to keep him contained, the chainsaw contained, and Manuel away from me with the pole.
Okay, did you have any bruises from when Manuel hit you on the back with the pole?
No,
And so he puts down the chainsaw for Roberto. Manuel goes and gets the receipt. And then that's just the end of it.
yes,
And you didn't call 911, correct?
no,
Even though he had just tried to attack you with a chainsaw.
correct.
Did you check if you had any injuries?
No.
Did you tell anyone that they had hit you with a pole?
I told the officers,
Okay, and then you were arrested that day, right?
yes, sir.
Yes. Trying to approach a witness.
Yes.
This is your N6 certification, right, from that day?
Yes, sir.
Okay. And you have a smirk on your face that day, right?
Yes, sir.
So you're telling this jury after you were attacked with a chainsaw, or two chainsaws actually, hit with a pole, and then wrongfully arrested, you had a smirk on your face.
Yes, sir.
I'll pass it with this judge.
Defense? Yes.
Mr. Huerta, did the officers ever truly give you a chance to tell your side of the story?
No,
Did they ever ask you if they could, check your hands or get any samples of your fingerprints or anything?
no,
Did you ever get that opportunity to tell the detective your side of the story?
no,
Did the CSI officer come by and ask you your side of the story?
no,
Did you ever get to tell your full story? I'm not talking about to us, your attorneys, but to anybody other than us, your attorneys, for the first time other than today?
no.
State?
We're done, obviously not excusing, Your Honor. No.
All right, you can step down.
This time the defense will rest.
State?
Stay close.
Defense?
Defense goes.
All right. Ladies and gentlemen of the jury, you've heard all the evidence in this case, but you're not allowed to start deliberating yet. I just have a couple of matters to take up on another docket, and then we will bring you back. All right, so remember, do not discuss anything that you've heard, but both the state and defense will have a chance to present closing arguments to each of you. All right, everyone, please rise for the jury. All right, everyone, please be seated. All right, so with regard to the jury charge, there is a jury charge that was emailed to both parties beforehand. There was the issue related to the defendant not testifying, and of course, we will remove that since the defendant did testify. Other than that, are there any objections to the jury charge from the state?
Will there be a different page added instead of that page?
Yes, I mean, it will be, that will be taken out, so.
But will there still be any?
Yes,
Okay.
the normal paragraph will be placed in there.
I would like to see that paragraph.
Okay.
And then the other request that we would make is on paragraph 4. Relating the manner and means. I believe that it should be first paragraph, pointing said deadly weapon at or in the direction of the complainant, or swinging said deadly weapon at or in the direction of the complainant.
All right, anything from the defense?
Just like, which portion of it was it, Marcus?
The manner and means, just that it should be discussed.
In the manner of its use and intended use. You would argue that it should be and your, just to follow the language of what was alleged in the indictment.
All right, that would be denied defense. All right, everybody, just give us a moment. And did you place this on mute?
Something else.
They're confirming over the jury charge.
Want us to give this to the clerk? Sir, or-
Yes.
Yes. Okay.
All right, Mr. Rodriguez.
Yes, Judge, present, ready.
Oh, for some reason I cannot hear you.
Uh-oh.
Can you say something now?
Yes, I can hear you, but
Okay,
your
Renee,
your
it's
Zoom
one of
says
those
you're
things where
muted.
He's whispering. And it's to make me feel like I can't hear. Just 1 second, it may be on our end.
Okay.
I always think it's funny if people were to talk, but no sound would come out and they're pretending like you can't hear it. Can you try now, Manny?
Yes. Can you hear me now, Judge?
Yes,
No.
still no sound.
Still no sound. Okay.
No sound.
We don't. It's unmuted. It's unmuted.
Just 1 moment, we're working on it.
Can
Got it.
someone else say something and see if we can test it?
All right, Joe Ray, could you say something so we can see if we can test it?
Yes, Judge, I can hear him.
Yes, yeah.
We good
It's on
now?
us. Just give us a second.
Okay.
It's on wrong publish. It's on,
Okay.
on Judge.
Sources?
Okay, how about now, testing?
Testing. Here we go.
Yes.
Yay.
All right, Mr. Rodriguez, you have Mr. Jenkins?
Yes, Judge.
Oh, not yet. Oh, no, not yet. We're waiting for the jury charge.
Okay.
All right, are you ready to proceed on Mr. Jenkins?
Yes, yes, Judge, we are. We're ready to proceed.
All right, the court is calling 2020 CR 0534, State of Texas versus Kevin Jenkins. Can I have the parties announced for the record for the state,
Joe Ray Garcia.
for the defense?
Manuel Rodriguez representing defendant, Mr. Kevin Jenkins.
And are you Mr. Jenkins?
Yes, ma'am.
We're proceeding by video because of the pandemic. Any objection from the state?
No, Your Honor.
Any objection from the defense?
None, Judge. Thank you.
Mr. Jenkins, I'm showing you what's entitled defendant's consent to appear by video conference. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm going to show you what's entitled motion to revoke deferred adjudication. I'm sorry, motion to enter adjudication of guilt and revoke community supervision. Did you review that document with your attorney? Did you understand it?
Your Honor.
I'm sorry?
I said yes, Your Honor.
Are you the same Kevin Jenkins who was placed on deferred adjudication in 2020 CR 0534 for the offense of unauthorized use of a vehicle on July 26, 2021 for a period of 2 years? Is that you?
Yes, ma'am.
Right, state?
Violated condition number 20. In Bexar County, Texas, the defendant, Kevin LaMike Jenkins, did then and there fail to report to the supervision officer as directed for the months of October 2021 and violated condition number 20.
How do you plead to that, true or not true?
True.
Violated condition number 22. On or about the 21st day of October 2021 in Bexar County, Texas, the defendant, Kevin LaMike Jenkins, did then and there fail to comply with the rules and regulations of the Bexar County Community Supervision and Corrections Department Intensive Supervision Gang Unit, and that the defendant failed to make himself available for 2 monthly face-to-face contacts in violation of condition number 22.
How do you plead to that, true or not true?
True, Your Honor.
The state waives the remaining allegations.
Any objections?
No objection, Judge.
Mr. Jenkins, did you understand by pleading true to violation of conditions 20 and 22, the court could find it true, grant the motion, find you guilty, not grant you community supervision, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Did you understand?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violations, conditions 20 and 22?
Yes, true.
Is there an agreement?
Yes, Judge. We ask that the court revoke and adjudicate and sentence the defendant to a term of 10 months state jail facility.
Is that the agreement?
Yes, it is. Yes, it is, Judge.
Mr. Jenkins, are you asking that the court follow that agreement?
Yes,
Are you waiving your right to appeal?
yes,
All right, the court will follow your agreement as previously stated. The court is finding violations of conditions 20 and 22 true. Granting the motion, finding you guilty, sentencing you 10 months in the state jail facility, give you credit for any time served. Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it and did you electronically sign it?
yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, Your Honor.
If you have a question over the definition of weapon or ammunition, you'll need to contact an attorney. Do you understand?
Yes, Your Honor.
All right, with that, we will go off the record. Mr. Jenkins, good luck to you. You didn't do very well on deferred adjudication. You're gonna have to start making better decisions in your life. Otherwise, you're gonna find yourself in and out of, the Bexar County Jail or other jails and in and out of prison. Do you understand?
Yes, Your Honor.
Do you have any children?
No, ma'am.
All
Working
right,
on
well,
one.
that may be a good start right now for you. Don't, go forth and procreate until you get your life together, okay?
Yes, ma'am.
All right, good luck to you, Mr. Jenkins.
Thanks.
Thank you, Mr. Rodriguez.
Thank you, Judge. Appreciate the time.
All right, have a great time at class tonight.
I will, Judge. May I be excused?
Yes.
Can I meet my attorney in the breakout room?
Just 1 second. I will send you to breakout room number 2. And Mr. Rodriguez, if you can make sure he comes back to the main room after you completed speaking to him.
Will do, Judge.
All right, state, Mr. Ramos, I don't have your email address, but I'm going to send to the state a copy of the jury charge, and then they can forward it to you.
There's no problem here. Thank you.
And state, I just sent that.
Judge,
And
Norma's making
Mr.
copies for them.
Yes,
Norma's making copies for them.
all right, thank you.
Uh-huh.
And Mr. Acevedo, are you ready?
Yes, sir.
All right, who are the prosecutors on? What is your client's?
Mr. Civil.
Who are the prosecutors on Silva?
I can do it, Judge.
If you guys could step back a little bit.
Yes, sir.
Judge, I can fill in. I don't know if Marcus.
Yes, Marcus is here.
Okay, thanks, Marcus.
Before we go on the record, we have the motion to revoke, and that has a new number 1, and the defendant pled true to the new number 1 in that motion to revoke, and then we have the sentencing.
Correct.
All right. All right, the court is calling 2017 CR 10818 and 2022 CR 1661W, State of Texas versus Stephen Ben Silva. Can I have parties announced for the record for the state,
Marcus Sanders.
for the defense?
Joseph Acevedo, Your Honor.
All right, and are you Mr. Silva?
Yes, Your Honor.
You enter a plea on February 16th to the offense of driving while intoxicated 3rd or more. According to the plea bargaining agreement, the state is recommending your application for community supervision. And in cause number 2017 CR 10818, you entered a plea of true to violation of condition number 1 on February 16th. Are both parties ready to proceed?
Yes, sir. Yes,
And
Judge.
defense, have you received the PSI report and did you review that report?
We have, Your Honor.
Any objections?
No, Your Honor.
All right, then. The state is in agreement. Is there anything you wish to say on behalf of your client?
Your Honor, with regards to the TAP evaluation, we're asking if the court would follow the intensive outpatient treatment. Also, I brought some supporting documents of his health in terms of he is highly susceptible, although he's been vaccinated, he's highly susceptible beyond any normal person, that if he were to contract COVID, it would be deadly for him, given his entire health condition. He has been, it's in the PSI report that he had a relapse, and he's been working on since this incident and has been compliant and alcohol-free and drug-free. Would ask if the court would follow the recommendations and put him on a stern zero tolerance.
Here's the court's concern. He was on, well, not deferred adjudication. He was on probation for driving while intoxicated third or more. And now he's picked up another driving while intoxicated case.
If you look at his history, Your Honor, at a very young age, well, if I may ask him a question, Your Honor.
Yes, could you raise your right hand for me, please? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand. Could you state your name for the record, please?
Stephen B. Silva.
All right, defense.
Now, Mr. Silva, you heard the court has a very serious concern about the fact that while you were on her probation, that you picked up this new DWI. Can you tell the court what was going on at the time that you found yourself having a relapse?
I had been an alcoholic for like 35 years, and I had found the solution by working at 12 steps of Alcoholics Anonymous. Cleaning up the wreckage of my past, I worked all the 12 steps. The only thing is that when COVID came in, I didn't have a place to go to my meetings. When they finally, when the COVID came in, I grabbed onto, with the best of my ability, prayed to God, who's my savior, and it was my sobriety was strong. But when everything, and I had my Zoom meetings, I was going to my Zoom meetings. But when they opened up the meetings again, I started going to my regular meetings. But then the governor said, you don't have to wear your mask anymore. So I felt in a dilemma, I couldn't go to meetings because of my health issues. So then I said, I'll go back to my Zoom meetings. But there was nobody at the Zoom meetings. So that's when I got caught up in my situation where I stopped going to my meetings. And that's when I started, I stopped going to meetings basically. That was, I need my meetings. It was a big part of my relapse, Your Honor.
And that's how you found yourself putting yourself in the situation you got yourself in.
Yes, it all started with I started wanting to feel different, and really what I started doing was started drinking energy drinks. And right there, when I wanted to feel different, I was looking to feel something different. Actually, I relapsed right there. I relapsed even before I even put any alcohol in. It was the disease centers in the mind.
So since the date of this most recent arrest to right now, what have you implemented in your life to make sure this doesn't happen again?
Well, before that, I started finding people who were like me, who have issues like me, who have issues like with heart disease and stuff. We're in the program. So we started our own groups. So we get together and we have our own meetings. So we feel safer like that, And so really we have smaller meetings, but there's about 5 or 6 of us that we get together. And now we have our own, the circuit has grown larger like that.
No.
And
Now, I showed the court documents of your health condition. In your own words, what is it? What's your understanding of your health condition?
I have pulmonary arterial hypertension. It's a narrowing of the blood vessels in the lungs. That's the main one. That's my main concern. And I need two medicines. One called opposite, the other one's called sildenafil. Those open up the veins in my lungs to allow my heart to push in
And
oxygen.
are those supplemented as far as payment? Because one of them is extremely expensive.
I've had to go to various, over the years, get help from different entities. And out of that, my last resort has been the pharmaceutical company.
And if you don't get that coverage, it's how much to?
Yeah, one of them's close to $10,000 a month. So,
Are you making a commitment to the community and to the court that you were going to stay clean and sober?
I make a commitment to the state. There's only one thing that I know that has gotten me sober, and that's working the steps, relationship with God, relationship with myself, cleaning up my character. Cleaning up
Tell you about it as soon as I get on. Mr. Leonard, what is your name? Why are you on a cell phone and you're in court?
I answered it because somebody called.
Well, let me just tell you this, you're in a courtroom. If you want to answer your phones, then what's going to end up happening is you're not going to be zooming from your house. You're going to be in the courtroom. Do you understand?
I apologize. I'm sorry. This is my first time ever being in Zoom.
Well, those are the rules of Zoom.
Okay, yes, ma'am.
Your Honor, I'm sorry. Listen, Your Honor, with all due respect, I was a hopeless alcoholic. The only thing I've ever known has been to save me, and in doing so, society too at large, has been by working the steps. And that's step 1, 2, and 3, my relationship with God. Step 3 to 7, my relationship with myself by working on my character, stop lying, cheating, and stealing. You know, cleaning up my relationship with others, the records of my past. 8 and 9, and then the maintenance steps, which is step 10, 11, and 12. And it all comes down to going to meetings, seeking God, and helping others. And that's how I became sober.
Are you employed?
I'm self-employed. I'm disabled, but I have a successful business. Now, I don't make much in the business, but by working that business, I've been able to get myself out of a rinky-dinky roach infested place where there's nothing but strippers and everybody at that time. I don't hold nothing against them, but I've gotten out of that place to a better, nicer place, apartment, to where I pay more money. I live modestly.
Okay. All right, this is what the court is going to do. The court is going to sentence you to 8 years in the prison, suspended and probated for 8 years, $1,000 fine probated, $60 to SAPD for testing. This will run concurrent with 2017 CR 10818. There's going to be a referral to felony drug court. If he's waitlisted on felony drug court, or if he's not accepted to felony drug court, then he's going to SATA. There's to be no driving while on probation. The court may consider that at some point in time, but for now, there's to be no driving. 150 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to obtain the COVID vaccination, but if you do with the booster shot, then 40 of those hours will be waived. DWI intervention, the VIP live, AA meetings, there's to be 90 meetings in 90 days. 2 years driver's license suspension, ignition interlock for the full term. So if there's a vehicle that's at your home, you're not driving it because you're not allowed to drive while you're on probation. But ignition interlock will be on any vehicle that is at your home. Do you understand?
Yes, Your Honor.
There's to be field visits 2 times per month, random. Proof of employment or SSI within 15 days. no employment as a home health care provider with minors, regular UAs, and regular reporting by Zoom or in person. And there's 10 days in the Bexar County Jail. I'll hold that in advance due to COVID. But again, if you're waitlisted for felony drug court, or if felony drug court does not accept you, you're going to be taken into custody and you're going to turn yourself in, you're going to SATF. Do you understand?
Yes, sir.
Do you understand?
I believe so.
What is it that you don't understand?
I think it's good news for me, that's all I know.
Okay. All right, in cause number 2017 CR 10818, as previously stated, the court found violation of condition number 1 true. The court will alter and amend conditions to include a referral to felony drug court. If not accepted or waitlisted, then he's just turn himself in for SATF. All right, Rebecca, is there anything else that he needs?
Judge, was there any restitution owed to anybody?
There's insurance, Your Honor.
No, I didn't see it listed as a part of
No,
the paperwork.
there's insurance and she references it.
Okay, let me find it, just 1 second.
Yes, sir.
All right, it's not listed in the paperwork, but in cause number 2022 CR 1661W, there'll be restitution if applicable. All right, so if there's some restitution that's owed, you're to pay that restitution. Mr. Acevedo, is it, if you think the restitution amount is not correct, then let the court know. So restitution, if any. All right.
In fact, we'll be providing that insurance as payment.
All right, is there anything else, Ms. Reyes?
No, ma'am.
All right, Mr. Silva, in cause number 2022 CR 1661W, showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Mr. Silva, you need to not drink alcohol at all. Some people, they can't drink alcohol because they can't stop once they start. Some people can. You're one of those people who it appears cannot. You understand?
Yes, definitely.
So whatever you need to do to remain clean and sober, that's legal, of course. You should focus on that. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Mr. Acevedo, you can take your client to the back to go over conditions with Ms. Reyes.
Okay.
And Judge, do you have the name of the person restitution is to be owed?
Yes.
No, it's not in the
Okay, I can
paperwork,
give
but
it to
I'm
you.
assuming, is it, because it appears that it may be owed to the insurance company.
The plea agreement was for Stacy Berry.
That's correct. That's correct.
Weird.
Yes, it's not listed here. That's
I-
why I tell everyone.
No, Judge, it's-
That's right. What, is my vision off? Oh, I am so sorry. We're back on the record, Brenda. My vision. See, this is what I mean when I say my glasses are for distance and not for a close. All right, there's to be restitution to Stacy Berry, STACEYBARRY, and that is in cause number 2022 CR 1661W. Thanks, Marcus.
Thank you.
Right, and if you'll go to the back though, take you to a breakout room back there.
Thank you.
You're welcome. And Mr. Acevedo,
Yes, sir.
when you go to the back, could you take these to the
Yes.
clerks? Thank you.
So Judge, I was thrown off by the tap. It looked like it was an old tap. That's what I got thrown off on. Thank you, Your Honor.
All right, no problem. Have a good one. All right, Norma, can you let them know L30 Jenkins can go back?
Yes, ma'am.
And who is Mr. Leonard waiting for?
I believe Norma was saying that he needed a different attorney assigned.
Mr. Leonard, who is your attorney?
My attorney was Anthony Smith.
All right, Ms. Ferguson or Mr. Leonard, we're going to recall that for tomorrow. We're going to see if we can get your attorney in tomorrow, Mr. Leonard.
Yes, ma'am.
All right, I'm going to send you, Mr. Leonard, thank you for your patience. Mr. Leonard, I'm going to send you to breakout room number 1, and you can be excused from that breakout room.
Yes, ma'am.
And the coordinator will meet you there.
Yes, ma'am.
And then Rebecca, if you could go to number 2,
Yes, ma'am.
well, probably number 1. And then
Okay.
Go from there. All right, Mr. Leonard. All right, we're back on the record in 2019 CR 11721. State and defense, have you had a chance to review the charge of court?
Ma'am.
Just Mr. Leonard. You can go to the breakout room. Go to the breakout room.
This is my first time. It didn't say join or nothing.
What type of phone do you have?
I'm on a tablet.
Tap the screen.
Tap the screen.
Yes, ma'am.
Do you see where it says breakout rooms?
All it says, share video participant, switch camera. It don't say breakout room.
All right. So,
I'm gonna hit more. All right. Okay. I see it.
all right, thank you.
All right.
It's a beautiful world we live in. All right. Let me see if Mr. Leonard is going. All right. State, any objections to the jury charge?
No objections.
Defense?
Your Honor, we just want to make sure that our record is clear in regards to the objection we made previously in that by changing the language on paragraph 4 to or effectively changes what was indicted. In that when the state indicted Mr. Huerta, they alleged that this and this happened, and by changing it to or, it allows for it to be in either or option. So we just want to make sure our record is clear and that we're objecting to that for the charge.
All right. That objection will be overruled. Are there any other objections to that defense?
No, Your Honor, other than that.
All right.
Gemini.
You asking? Oh, he needs his mom. Just 1 second. Mr. Leonard, just click on the box.
It should be like upper left corner.
Oh, wait a minute. He's there now. All right. How much time are you asking for, state?
25.
Oh, no, we don't, I mean, no.
20.
We can do this in 15 minutes, right? 15 minutes aside. And I'll give you what extra?
A little extra if we need it.
Yes.
Okay, thank you.
Is 15 minutes enough side for the defense?
I hope so.
Getting ready?
I was
Yes.
serious about that hour.
Were you serious
No.
about an hour?
I think I can get that.
Okay.
Will we get a warning on that time, Judge? Can you give me about like a 2-minute warning? when we're-
Okay,
when we're
sure.
getting close?
Anytime announcements for,
Judge, can you give Brittany a 5-minute warning when she's used 5 minutes? And then me when I have 1 minute left.
all right, so Ms. State, Brittany, you're asking for 5 minutes.
Yes, Judge, if you could just, if I get to 4 minutes, if you could give me notice.
Sure. And then defense, you just want a total of 2 minutes.
Yes, sir.
Ready, Your Honor?
Yes.
All right, to the jury.
All right, everyone, please be seated. All right, ladies and gentlemen, the jury, I'm going to read to you what is entitled charge of court. You will be given a copy of this to take back with you in the jury room. Members of the jury, the defendant, Roland HUERTA, stands charged by indictment with the offense of aggravated assault with a deadly weapon, alleged to have been committed on or about the 5th day of March 2018 in Bexar County, Texas. The defendant has pleaded not guilty. 1, our law provides that a person commits an offense if the person intentionally or knowingly threatens another with imminent bodily injury. A person commits aggravated assault if the person commits an assault as defined above and uses or exhibits a deadly weapon during the commission of the assault. 2, bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. Deadly weapon means anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. 3, a person acts intentionally or with intent with respect to the nature of his conduct when it is his conscious, objective, or desire to engage in the conduct. A person acts knowingly or with knowledge with respect to the nature of his conduct or to circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. 4, now, if you find from the evidence beyond a reasonable doubt that on or about the 5th day of March 2018 in Bexar County, Texas, the defendant, Roland HUERTA, did use or exhibit a deadly weapon, namely a chainsaw, that in the manner of its use or intended use was capable of causing death or serious bodily injury, and Roland HUERTA did intentionally or knowingly threaten imminent bodily injury to Rigoberto Archila Valle by pointing said deadly weapon at or in the direction of Rigoberto Archila Valle, or swinging said deadly weapon at or in the direction of Rigoberto Archila Valle, then you will find the defendant guilty of aggravated assault with a deadly weapon as charged in an indictment. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty. To ensure that the jury, the court, and the parties all receive the same testimony, when a party or a witness informed the court that they did not speak English, the services of an interpreter was employed. You are instructed that you as the jury are to base your deliberations on the questions as they came from the attorneys in the English language and the responses from the witness as they came from the interpreter in the English language. Written or recorded statements made by a witness to investigators or other officers, or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. The grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in determining whether the defendant is guilty or not guilty. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. In the event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you and these instructions, you will acquit him and say by your verdict, not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any facts or persons connected with this case which is not shown by the evidence. Do not let bias, prejudice, or sympathy play any part in your deliberations. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or media, such as telephone, cell phone, smartphone, iPhone, or computer, the internet or any internet service, or any text or instant messaging service, or any internet chat room, blog, or website to communicate with anyone any information about this case, or to conduct any research about this case until I accept your verdict. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given the testimony, but the law of the case you must receive from the court as contained in these instructions and be governed thereby. You must disregard any comment or statement made by the court during the trial or in these instructions which may seem to indicate an opinion with respect to any fact or verdict to be reached in this case. No such indication was or is intended. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate form attached to this charge and signing his or her name as presiding juror. The form is not intended to suggest to you what your verdict should be. Your sole duty at this time is to determine whether the defendant is guilty under the indictment in this cause and restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. If the jury wishes to communicate with the court, the presiding juror shall notify the bailiff. Any communications relative to the case must be written, prepared by the presiding juror, and shall be submitted to the court through the bailiff. Respectfully submitted, Judge Stephanie Boyd of the 187th District Court in Bexar County. Suitable jury forms are attached. State?
All right, can I switch?
Yes.
May it please the court? Ladies and gentlemen, yesterday during court hour, we told you that in order to find the defendant guilty, you have to prove prove each and every element of this offense beyond a reasonable doubt. And as the state, that burden stays with us throughout the entire trial. I also want to remind you that beyond a reasonable doubt does not mean beyond all doubt, and it does not mean with 100% certainty, and that you are also able to use your common sense. These are the elements that we had to prove to you, and we did just that. We met our burden, and we proved each and every element beyond a reasonable doubt. When you go back to deliberate, you will only be allowed to consider the evidence that has been presented to you today. You will be able to take back the evidence that was shown from the stand, which includes the photographs. Although we reference the police reports, you won't be able to take those back with you. It's not because we don't want you to see them. It's simply that the law does not allow us. Yesterday, we also discussed that it is the defendant's constitutional right to not testify, and that if he didn't, you're not allowed to use that against him. It also goes on the opposite side. Today, he decided to testify, but that does not mean that you get to give him brownie points or extra credit because he made that decision. Defense counsel is about to come up here and present their closing argument to you. Don't let them lead you down a rabbit hole. Remember the evidence that you have heard. You are the judges of the credibility of the evidence and the testimony that you heard today. After defense counsel presents their closing, Marcus is going to get up here, and when he's done, we are going to ask that you find the defendant guilty.
Defense?
I have a moment to set my thought.
Yes.
Can I proceed, Your Honor?
Yes.
Incomplete investigation. Unanswered questions. That's what I told you were going to see at the beginning of this trial. And I told you the devil's in the details. There are a lot of different details today. They want you to believe that I'm going to take you down a rabbit hole and try to confuse you. What I really want to do is take you down the highway of truth. Down the highway, huge highway of all the things that you didn't get. When we have unanswered questions, the only path that it leads to is to finding the right. Why? Because as the state mentioned to you, you had to prove their case beyond a reasonable doubt. Now they're very clear to tell you it doesn't mean all doubt. They're right. No, we're not talking about doubts that aliens came down and did something. Right? We're talking about reasonable doubts, reasonable inferences, things that you can reasonably ask for. And they felt that they proved their case. They told you, this is what we're going to prove. Jury, we're going to prove to you that on this date, Roland Huerta did come and use this chainsaw, and he did point it in the direction of Rigo, and that he intended to cause bodily harm. That's what they told you they were going to prove. And it's their burden, they know that. They just told you. So they're going to bring you the best evidence that they've got, their best witnesses. They're going to bring you everything that they've got. So who did you hear from? 4 witnesses today. Right? You get Rigo, who takes the stand. Rigo, for the first time ever, today tells you that he was punched in the face. Never told anybody that in any other statement, not when he talked to the officer, Rutherford, not when he talked to Officer Villarreal, not when he gave his written statement. 4 years later is the first time he tells anybody that that's what happened. Now, we know he's got a potential motive as to why he'd be making this story. I'm not going to sit here and call anybody a liar. Nobody knows the truth other than the people that were there. All we can do is look at the evidence that was given to us and the evidence that was not presented to us, all right? Because who did we hear from next? Manuel, right? And his story changed up a little bit, and he was a little confused. And I don't know whether to chalk it up to it's been 4 years, or do they not have their story straight, or did it not go down the way that it happened? I can't read minds. I can't ask you to read minds, right? But I know he was saying, and now Manuel was punched in the back, or Rito was punched in the back. Again, for the first time. You heard the officers tell you. Nobody ever told me. If they did, I would have put it in my report. Wasn't there. I don't want to beat up on the officers doing their job. Unfortunately, in this situation, I don't feel they did the proper job. Maybe that's on them. Maybe they were passing the buck to somebody else, right? Thinking Detective Browser's got this, or the CSI's got this. You know, even the arresting officer had to admit that he wrote in his report he was told to make the arrest when somebody else finished their investigation. Right? Huge questions. Who did we hear from? Who could have potentially filled in those gaps? Where's Manuel's wife who was there? She could have told us what happened. What did she see? She was parked right there down, or not even down the street in the same driveway. Where is she? Where's Detective Bowser? The one who did this investigation. Where's the CSI investigator? The one who took these photographs? Who gathered the evidence? Were they able to pull fingerprints? We don't know. So what I want you to understand here is I've been lucky in my life. I've been able to travel to other states, see other courtrooms. The way that this is set up here, it's not by accident. This is by design. Right? Wherever a juror's box is, the state's table is always next to them. They sit in the defense far away. Why? Because the defense doesn't have to do anything. It's the state's burden. The burden sits on this table the entire trial. It never shifts to us. We never had to present one shred of evidence. We don't have to bring you anybody. We don't have to subpoena the wife. We don't have to bring the detective. We don't have to bring the CSI investigator. That is the state's job. They bring you their best. They show you their best. Unfortunately, it didn't happen. We don't have the burden of proving to you anybody's innocence. We don't have the burden of showing to you what truly happened. It's difficult to do, right? And as you heard, Roland didn't have to take the stand. He wanted to tell you the story. He wanted to tell you that. He did. And at the end of the day, though, when we look at this case, we still have so many questions. Is it unreasonable to ask an officer to do a proper investigation? Is it unreasonable to ask that he record his interviews? Whether it be video, whether it be audio, is it unreasonable for him to go and ask a neighbor, hey, do you have a camera that happens to point in this direction? Is it unreasonable to ask, hey, detective, you know what? I've got one guy who's saying he didn't pick up that chainsaw. It was somebody else who picked it up. Can you pull prints off of it? Like that, we'll find out who had it, who picked it up. Who's telling the truth and who's not? Is it unreasonable to ask for that when we're looking at such a serious charge? This isn't a traffic ticket. Is it unreasonable to believe that the wife couldn't come testify, the detective couldn't come testify, the investigator, the CSI couldn't come testify? Right? Do we truly believe that an officer told them, keep your story short, don't tell us everything? Have just the important parts. And they just left out important details in the question. That's the back of the I submit to you that it's not. Those are reasonable doubts. If I was asking you to believe that Mayman came down, or if I was asking you to believe it was Roland's twin brother that you never met and wasn't here today, being unreasonable. It's not what I'm doing. I'm asking for a reasonable investigation. And unfortunately, we have an incomplete investigation. That's the only truth that we know. So what does all this mean? At the end of the day, we've got our burden of proof. We talked a lot about that. You remember Mordire, I kind of stood right here and I was explaining to you as if we were on a football field. And we started with reasonable suspicion right here in order to get pulled over. And then I jumped over and I'm like, hey, probable cause. And you heard the officer talk a little bit about probable cause, right? That's what he was trying to establish, whether or not he had enough to make an arrest. And that's what they believe they did, right? But that's not the burden that we're dealing with here, right? We jumped one over and we talked about that car accident taking somebody's money. And then we jumped even further over here and we started talking about taking someone's child. Started getting real serious, right? You take it a step further beyond a reasonable doubt. That's the burden the state had to prove to you. From there to here, get you past all reasonable doubts.
Judge, I'm gonna object the misstatement of the law.
All right, ladies and gentlemen of the jury, the law comes from the court. Does everyone understand? All right, defense.
Beyond all reasonable doubt. Can't have a reasonable defense. You're gonna get a jury charge. Everything that the judge just read to you. It'll look like this. You're gonna get to go back and you're gonna deliberate. Remember, I talked to you about picking a foreman, right? That foreman's gonna get to speak for you. When I say they're gonna speak for you, it doesn't mean that they're gonna come out and say what each of you want to have happen. When you go to the back, you reach your determination, you're gonna have a verdict. I have that verdict form here. And I also have a picture for you there that you can look at. You're gonna have two options there. Your juror foreman is gonna be the one to sign for you. I have an example for you there. I'm not telling you to sign as Oprah Winfrey. That's Oprah Winfrey's signature. You'll sign as your signature. But the only logical conclusion that we can come to in this verdict form, when we look at everything that we've got, when we look at the incomplete investigation, it's not guilty. It's okay to demand more from the state. It's okay to hold them to their burden. And it's okay to say we are not okay as a community, that this is what our officers have done in this case. They need to do better. You need to send that message to them and they can tell the officers, hey, next time it is not okay what you did in this case. Next time you make sure you talk to both sides, you get both statements. And if it's not consistent, find me something else that shows it is. That's okay. You can tell them to send a message. And I think it really must be. For our community's sake, it really must be sent to them that this is not acceptable. We cannot have people's lives in balance with these types of investigations. This is where we send that message. Remember the team innocence. We have to change it. Nobody else gets the benefit of the doubt. They're going to want you to believe, oh, look at his picture. He was smirking. He's smirking. Really? That's what they want you to believe? That's the evidence that they have? Okay, that means he's guilty? No. Ask them the question. Why didn't you bring me anybody? Where's the detective? Ask them. Because the way this is designed, I'm not going to get back up and speak. Since it's their burden, they get the last word. They're going to get to talk to you last, and I'm not going to get to respond to anything that they say. But I submit to you, they're not going to be able to answer those questions, and it's not sufficient as to why they didn't bring those witnesses. It's not enough. This is a serious offense, and you as the jury have the right to know every answer to your question before you decide somebody's guilty. They didn't meet that burden. You have to find them.
State.
So I started off this trial talking about how life is about choices. Told you that we were here yesterday and we're here for the trial because on March 5th, 2018, the defendant, he made choices. And even though life is about choices, it's also about consequences. We don't get to choose our consequences. On that day, Rigoberto, they didn't get to choose the consequences. Roland controlled that. So I want to respond to a couple things that the defense said before I get into the jury charge and then some of the evidence. He said that unanswered questions equals not guilty. that's not true. You can have questions, and this is something we talked about going retire. You can have questions about this example that I brought up was motive, why he did it. Fortunately, that was answered in this case. We know why he did it. Because he was angry that they stole his job from him. If you have a doubt, the first question that you must ask yourself is, well, first, one, do I have a doubt? Two, is it reasonable? And then three, does it go to one of the elements of the offense? And that's in the jury charge, and I'll show you what's that. So if you have just a random question about something that happened that day, if it doesn't go to one of the elements, then it doesn't matter. And that's what defense wants to do. Like Brittany said, they want to take you down a rabbit hole, talk about why the officers didn't do this. If you can't attack the facts, they try to attack the investigation when the facts aren't in the favor. Rigoberto explained why he did, Rigoberto explained why he didn't mention the punch. He said because that wasn't the most important part. Obviously, getting attacked with a chainsaw is the most important part. And his understanding, you could tell that he speaks Spanish, but he also understood some English. You can pick up on that because he would answer some of the questions a little bit before the jury would finish. But Spanish is his first language, he's fluent in it. And so him and the officers, the deputies, they communicated through sort of broken English. So his understanding was tell the most important part, and obviously the most important part was the chainsaw. Defense questioned him about the U visa and tries to imply that that's a motive for him to lie. But the testimony and the only evidence that you have is that he didn't even know what a U visa was before the offense happened. And it wasn't until after that he learned of a U visa, and then it wasn't until after that he applied for a U visa. And there's been no evidence that he's actually been granted a U visa. Defense also talked about the different versions regarding the punch, whether it was in the face or in the back. And I guess my response to that is it's sort of it cuts both ways. Because if we have witnesses, multiple witnesses give the exact same version, defense is going to jump up and down that they got together and got their story like the same, that they're lying. And if they give different versions, then they're lying. It's like they're lying no matter what. But you got to remember, this is a 2018 case. It was over 4 years ago. And so their memory may not be the best. But again, we're not alleging that question. That's not one of the elements. It's about the chainsaw attack. Defense brought up the fact that we didn't bring certain witnesses, the wife of Manuel. And he even questioned about the driveway being long, that she was in the vehicle, and that she didn't see anything, or that she probably didn't see anything. He asked about the detective. And as you all sort of probably picked up on, hearsay is a thing. We can't bring in what someone else said. And so if the detective didn't do anything besides get statements from people, she can't just come in and say, this is what they told me. That's why we have the witnesses. The last person they mentioned was the CSI, same thing. The CSI only took pictures. Why do we need a CSI to come in and say, hey, I took these pictures when we get the pictures in through the witnesses? The witnesses say, that's how it's seen. So that's why we didn't bring the witnesses, because we don't want to waste your time. We do what we need to prove the case to you, make sure that we get all the evidence together. So I want to talk about the charge a little bit. So this is what you're going to take back with you. It's the charge of the court. This is the law. This is what you're supposed to follow. So first part I want to highlight, our law provides that a person commits an assault if the person intentionally or knowingly threatens another with imminent bodily injury. The reason we talked about this during Berdara is because I know that some people think, oh, it was just a threat, so it's not a big deal. But the reason that this is the law is because those threats could turn more serious, that it could have resulted in serious bodily injury. Fortunately, it didn't on this occasion, but all of you agreed that you could follow the law and that if someone threatens imminent bodily injury, that you would be capable of finding that person guilty. The second part, the way that because I told you that we have to prove how he committed the assault. And so it's by pointing said deadly weapon at or in the direction of Rigoberto Archilavalle, or swinging said deadly weapon at or in the direction of Rigoberto. So we don't have to prove both manner of means, it's either. So if you think that he either swung it or that he pointed it at him, that is still an aggravated assault and we prove that element. I highlighted this part just to go back to what I said earlier. We have the burden of proof the defendant guilty beyond a reasonable doubt, but that's to each and every element of the offense, not unnecessary extraneous facts or details that don't matter regarding the actual offense. Do not let bias, prejudice, or sympathy play any part in your deliberations. And then lastly, you are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given. The testimony, but the law of the case you must receive from the court as contained in these instructions and be governed thereby. So let's talk about the evidence, the testimony that came from the stand. The brothers told you a clear story. Defendant testified. Defendants, they don't always testify. Fortunately for us, he did in this situation, because you can think about what he said and just think, did it make sense? If while he was testifying, if multiple times you were like, wait, what? It doesn't make sense. He's not credible. One thing I want to show you is this picture. This is a door that the defendant says victim bumped into and it broke. But if you look at the picture, you see a clear line across, like a chainsaw went across it. This isn't someone bumping into the door and shattering it. This is a chainsaw going across and breaking the glass. He also testified that he wasn't upset that they stole a job from him. He wasn't upset that they had stolen a tool from him, and that he just went over and got the tool. He testified that the victim, after attacking him with a chainsaw, all of a sudden decided to just stop attacking him. And that after they attacked him, he just left. Didn't call 911, he went about his day. Does any of that make sense to you all? We've proven this case to you beyond a reasonable doubt. We're asking that you now hold Roland HUERTA accountable for his actions and find him guilty. Thank you.
All right, ladies and gentlemen of the jury, I kept telling you that I would let you know when it was time for you to deliberate. So the deputy is going to take you to the back and you have the court's permission to begin deliberation. But if I could have the alternate juror remain behind, please. Everyone, please rise for the jury. And that would be Armstrong. If you're going to remain behind, please. Could you make sure you're on mute?
I was using that.
All right, we're back on the record in cause number, sorry. We're back on the record in cause number 2019. CR. I can't see you
I'm
around the
here.
corner. Okay, thanks. 11721, State of Texas versus Roland Huerta. For the state, please.
Marcus Sanders.
For the defense.
Rick Rollins, Your Honor.
All right, the jury has presented a question, and the question is, what was the specific list of the elements must be proven by the state, question mark? Have both parties had a chance to confer over that question?
Yes,
State, defense.
Yes, Your Honor.
Any objections to the supplemental charge being, members of the jury, with reference to your inquiry, you have all the law before you. Please continue your deliberations. Any objections from the state?
No objection.
Any objections from the defense?
No objections, Your Honor.
Any objections to sending this supplemental charge back to the jurors, or would you all like them brought into the courtroom, state?
No objection to sending it back.
No objection to sending it back, Your Honor.
Okay. All right. Mr. Because we have to have the court. All right, court is calling 2019 CR 11721, State of Texas versus Roland HUERTA. Do I have parties announced for the record for the state,
Marcus Sanders.
for the defense?
Rick Ramos for the defense.
All right, the jurors have a question. Their question is, we can't seem to make a unanimous decision. Where do we go from here? The supplemental charge the court wants to send back is the following. Members of the jury, with reference to your inquiry, you now have before you all the testimony, exhibits, and evidence that was admitted, and you are instructed to continue your deliberations. Any objections to the supplemental charge, state?
No objection.
Defense?
No, from the defense, Your Honor.
Any objection from the state to this being sent back to the jurors, or would you prefer the jurors be brought out?
No objection to being sent back.
Defense, any objection?
No objection to being sent back, Your Honor.
All right, ladies and gentlemen, the jury, the court is in receipt of your note. So I have a question for you. I understand that you would like something to eat. If you want something to eat, the court can, of course, make sure that food is brought in. Usually the food that's brought in is maybe pizza or something of that nature, and you can continue to deliberate. Or if you would like to go home and come back to tomorrow and continue to deliberate. So let it marinate. Think about it for a little bit. So how many of you would like to continue with the deliberation tomorrow? All right, bye. Sorry. All right, so it is 11-1 for continuing to deliberate. And the one juror who wants to continue to deliberate, are you okay with coming back tomorrow? Thank you so much. All right, so what we're going to do is we're going to come back and I'm going to ask that you all be back here tomorrow at 10 o'clock, okay? 10 a.m. That'll give you some chance to sleep in, have breakfast, and we're going to do our best to make sure that there's extra water here, okay? All right, so now that I'm allowing you to go home, you're not allowed to be deliberating at your home, right? You cannot discuss any of the evidence or testimony that you've heard or seen in this case with people, your friends and relatives at home or anyone you know at home and say, hey, what do you think? What would you do? That is completely your decision, and deliberation is only to start tomorrow when you are all present in the jury room at 10. Does everyone understand? All right, thank you. All right, everyone, please rise for the jurors. And Deputy Laura will show you all which way to get out of the building. Oh, please be seated.
Thank you.